we have spent the earlier part of time discussing what this creature of an LPA might be, the form that it might take, and the powers that the donees may have under a Form 1 and a Form 2. Okay. Now I would like to apply those concepts, right, and to a few case studies to see how it actually bears out in reality. Okay, so the first case study we have here is a Mr. R, right, a married man who unfortunately suffered a stroke, right. Essentially, he is not able to respond. He is incapacitated, mentally incapacitated. Unfortunately, he has 2 minor children, right? And the wife sought compensation from weaker and of course insurance compensation. The compensation monies can be set aside for his medical treatment, future medical needs, and the kids' education expenses, right? But the process to get there will be very onerous and painful for the poor wife, right? If there was no LPA in place, okay? So what she has to do essentially is to apply for a deputyship through a court process, right? And by way of the deputyship, the order given down by the courts, right? Then the wife will be able to act on his behalf in respect of the personal welfare and the property and essentially financial matters, okay? So as you can see, even though eventually she was able to avail herself of the insurance and his accounts, right, his personal monies, but the whole process took it's a very onerous process, right? So I would like to talk a little bit about what is this onerous process about, okay? So this is what we call a deputyship, right? Where you fail to make an LPA in time before you lose mental capacity, and what happens is that immediately your family members cannot access assets which are in your sole name only, right? Of course, in joint accounts or in joint names, there's no issue at all, right? And in doing so, they can only access the assets by filing a deputyship in court, right? To just contrast the kind of inconvenience, right, of filing a deputyship, I've contrasted the deputyship with an LPA, right? I put out here as the locus of decision, right? Under a deputyship, the locus of decision as to who might make those decisions on your behalf, that locus is actually the proposed deputy, right? So it could be the wife in the earlier case. That person, the deputy, the proposed deputy, would then have to make those decisions and think about how propose to court, right? How to make those decisions on your behalf, right? We contrast that with LPA, where the decision, where essentially yourself, right, you will decide how you want your personal affairs and your properties to be actually conducted. Okay, the areas of decision, if you look at it, it actually mirrors the 2 broad areas under an LPA, right? So as a deputy, you have to then propose to court what is your proposed care plan for the person who has lost capacity, right? And that actually contrasts, maps nicely with the personal welfare portion, right? Where you can, under LPA, you decide for yourself how you want your personal affairs to be conducted, okay? The specific powers in relation to affairs, that's the financial aspect, okay? That again maps with the property and affairs, which under an LPA, you can actually draft how you want your affairs and properties to actually be dealt with, right? So the deputy will then have to apply, right, propose and apply to the courts to be given specific powers, right, to be able to act for you, right, when you're incapacitated. Okay, the beneficiaries under a deputyship will be essentially the incapacitated persons only, but under a Form 2 LPA, if you recall, right, the donee can access the funds to actually benefit third-party beneficiaries if permitted under the Form 2. Okay, the burdens of applying for a deputyship is that the proposed deputy will also have to seek consent from relevant persons, right, to essentially be able to be appointed the deputy. So, for instance, if let's say, going back to the earlier case study, the wife would perhaps have to seek consent from siblings, right, of her husband, right, to essentially ask them, do they permit her to be the deputy, to seek, to essentially make the court application, right? And after that, right, there's also a lot of accounting, right? There's you have to prepare annual reports to the Office of the Public Guardian on the decisions that you have made on behalf of the person who has lost capacity, right? And in doing so, to document that you have made those decisions and make those decisions well, you also have to keep diligent records like receipts, or statements of accounts as to how those monies were being used, right? You contrast that with essentially under the LPA, right? You don't need to actually seek consent from anybody if, as a donee, right? If you are authorized under the LPA, in acting in the best interest of the donor, you don't have to seek consent from other parties, all right? Under the LPA also, you are not required to do a post facto justification of your decisions, right? As long as you have acted in the best interest of the donor. Okay. Next, we discuss this other case study, right, which illustrates how actually the LPA only kicks in during incapacity. Okay, Mr. John is a bachelor, lives alone, right? He has some medical issues, right? And he's concerned that no one will have access to his account to pay for his medical expenses. He wants to appoint his niece, right, to be able to deal with his affairs, right? But he's not sure as to whether, while he's well right now, does he need to appoint the niece as a joint account holder to essentially authorize her to access the joint account when he's well, right? Actually, the answer is no, right? Because Mr. John can just make an LPA appointing the niece as a donee, right, in respect of the financial aspects and also in respect of personal affairs, right, if he's comfortable. And essentially, he will retain sole control of the accounts. He doesn't have to make the niece a joint account holder or to authorize her while he's well, because the LPA will only kick in when he is mentally incapacitated. And while he has capacity, he will have full liberty to, of course, manage his financial affairs. Next, I want to talk a little bit about how an LPA can also be crafted, right, to accommodate sensitive family dynamics, right? So here we have Emily, a healthy 60-year-old retiree. She has 2 siblings, okay? She wants to make an LPA appointing her sister, Doris, as donee for personal welfare matters. And unfortunately, Doris, right, does not get along well with the other sibling, okay? But Emily herself does not wish to be cut out from her brother Mark, okay? So in the LPA, we can actually restrict the powers of Doris, right? Because Doris is the donee, right? So we can restrict the powers of Doris such that Doris is not able to restrict Mark from visiting Emily, okay? So while Emily gives Doris the donee for personal welfare matters, right, they can be restricted to prevent her from restricting Mark from visiting Emily. So the powers of the donee can be restricted to actually accommodate certain family dynamics that you may be uncomfortable with, or you want some kind of assurance that certain family members are not cut out from your lives. Next, we talk a little bit about a situation which is quite common for myself as well. A young couple married with young children, right? The natural choice will, of course, be to appoint your spouse as the donee, right? And that's all well and good, right? But to the extent that, there may be some concern that the spouse will pass away or lose mental capacity before yourself, then it will be useful to actually appoint a trusted family member, right, to act as the replacement or alternate donee when your spouse is not able to act on your behalf.